Marcus was in his own driveway when the argument turned physical. His neighbor shoved him first, and Marcus pushed back. 20 minutes later, he was in handcuffs. He thought the stand your ground law in Florida meant that he had every right to defend himself on his own property. Millions of Floridians believe the same, and most of them are wrong about how it actually works. There is a hearing most people have never heard of that can stop charges before they ever reach a jury. And there are mistakes people make in the first 5 minutes after a confrontation that guarantee they will never get that chance. My name is Susan Lawson. I'm a board-certified criminal trial law attorney and co-founder of Lawson and Simmons in South Florida. Florida statute 776.012 gives you the right to use force, including deadly force, if you reasonably believe it is necessary to prevent imminent death or great harm to yourself or someone else. The critical word here is reasonably. It is about what a reasonable person in the same situation would have believed. And you have no duty to retreat. That is the part everyone remembers. You do not have to run, back away, or try to escape before defending yourself. You can stand your ground anywhere you have a legal right to be. But that right comes with conditions most people never learn about until it is too late. This is where the myth falls apart. Stand your ground does not apply if you were the initial aggressor. If you started the confrontation, escalated a verbal argument into a physical one, or provoked the other person into attacking you, you lose the protection of the statute entirely. Florida courts look at the entire sequence of events, not just the moment you decided to fight back. It also does not apply if you were engaged in criminal activity at the time. If you are committing a crime and a confrontation breaks out, stand your ground is off the table. And it does not give you the right to use deadly force in response to a non-deadly threat. Someone shoved you in a parking lot does not justify pulling a firearm. The force you use has to be proportional to the threat you face. In the cases I have handled, the number one reason stand your ground defenses fail is that the person claiming self-defense did something earlier in the encounter that a prosecutor can point out and say, you started this. A text message sent before the confrontation, a phone call where you said something threatening, walking over to someone's property to confront them face to face. That one action can undo everything. This is the part most people don't know exists. Before your case ever goes to trial, your attorney, and we do this all the time, can file a motion for a stand your ground immunity hearing. This is a pretrial hearing where a judge and not a jury reviews the evidence and decides whether stand your ground applies to your situation. If the judge rules in your favor, the charges are dismissed, not reduced, not plea or bargain, dismissed, and you cannot be civilly sued for the same incident. This hearing is one of the most powerful tools in Florida criminal defense. The standard changed in 2017 in a way that made it even stronger. Before that change, the burden was on the defendant to prove self-defense by a preponderance of the evidence. Now, the burden has shifted to the prosecution. The state has to prove by clear and convincing evidence that stand your ground does not apply to your case. That is a significant hurdle for prosecutors, and it is the reason many self-defense cases never reach a courtroom. But here is the thing. The immunity hearing only works if the evidence supports it. And that brings us to the part that determines whether you even get the chance. Have you ever been in a situation where you had to defend yourself and you wondered whether the law was on your side? Drop in the comments. I have talked to dozens of people who assumed they were protected and had no idea what the law actually required of them. The biggest mistake happens before anyone calls a lawyer. You talk. You explain what happened to the officers on the scene, thinking honesty will help your case. In my experience, the clients who have the hardest time at the immunity hearing are the ones who give statements to the police before talking to an attorney. Every word you say becomes evidence, and the officers are trained to ask questions in a way that makes your answers sound like admissions. The second mistake is failing to preserve evidence. Surveillance footage from nearby cameras disappears. Ring doorbell recordings get overwritten. Text messages and voicemails from other people get deleted. Witness contact information gets lost. All of the evidence that can support your claim at the immunity hearing, and it starts vanishing within days. The third mistake is confusing the castle doctrine with stand your ground. Castle doctrine applies specifically inside your home, your occupied vehicle, or your dwelling. It creates a presumption that you were in fear of death or great bodily harm. Stand your ground applies anywhere you have a legal right to be, but it does not carry that same presumption. Using the wrong legal framework in your defense can cost you the hearing. They overlap in certain situations, but the legal standards are different, and that distinction matters. The fourth mistake is waiting. Evidence degrades, witness forgets details, and the window for filing a stand your ground motion has strategic timing considerations. The earlier your attorney can review what happened and start building the immunity argument, the stronger that argument is going to be. I've seen cases where clients waited weeks to hire an attorney, and by then the surveillance footage was gone. The best witnesses could not remember the specifics. If you are involved in a situation where you use force to defend yourself, 3 things matter immediately. First, do not give statements to law enforcement without an attorney present. You have the right to remain silent, and using it is not an admission of guilt. Second, preserve every piece of evidence you can find. Photos of injuries, screenshots and messages, names and phone numbers of anyone who witnessed what happened, and any video footage from the area. Third, contact an attorney, such as our firm, who has handled stand your ground hearings in Florida, because that pretrial hearing is your best chance to end this before it goes any further. Florida has other laws right now that most people do not know about. The next video covers one that just changed and affects every driver in this state. If you have ever been pulled over after having a drink, you need to see what Florida just did. If you're dealing with a situation like this right now, our number is in the description. What would you do if someone shoved you in your own driveway? Tell me in the comments below.